Hi, everyone. I'm Ericka Adler, shareholder and leader of the healthcare practice at Roetzel Andress. Today, I want to talk to you about how a practice should handle a notice of termination from an employee. And I'm talking about a notice of termination without cause, meaning that the employee has indicated they're going to be leaving in 60, 90, 120 days, whatever that time period is. These are the steps that you should be following. First, has the employee given the correct amount of notice? Make sure you look at their employment agreement and confirm that the notice amount of time given is correct. If not, you want to set the employee straight about your expectations. Remember, the parties can always agree to a shorter or longer amount of notice as long as it's mutually agreed upon. Second, and this may or may not be important to you, was proper notice given? Most contracts require that notice be given a certain way, either in writing, in person, FedEx overnight, but sometimes employees just send an email. However, if you got the email and it's okay with you, then that is acceptable. If it is not, then you need to inform the employee that proper notice has not been given. Third, what happens once the clock starts running on that notice period? Well, this is important. Both parties need to continue to meet their obligations under the agreement. For the employee, that means they continue to work just for the employer, to perform their services as described in the employment agreement, and to show loyalty to the employer, meaning they aren't working for someone else, they're not promoting someone else's practice. While they can get ready to leave, they can negotiate a contract with a new employer. They could even set up a new practice entity until the very last day they work with you. They only work for your practice. From the employer's perspective, you must continue to meet your obligations. That may mean providing support staff, billing, and certainly compensating them as described in their employment agreement. If you don't want that employee to come in anymore, for whatever reason that may be, you make sure that you continue to compensate them in accordance with the agreement unless the document indicates otherwise. As I mentioned, the parties can certainly agree to a shorter notice period, and that may be something that is negotiated. Now, what I like to recommend is that a letter be sent to the employee confirming that the parties will continue to operate in accordance with the terms of the agreement, but also clarifying a couple of other points, including what will the last day be? Who is responsible for the malpractice insurance? Who will be contacting patients, referral sources, or otherwise? Sometimes that's spelled out in the employment agreement and sometimes it's not. Remember, typically the patients belong to the practice, so the practice does control that process, and that's something that the practice should be thinking about in terms of giving notice to patients before the end of the notice period. Is there a non-solicitation provision, a geographic non-compete? Certainly you want to be reminding the employee about the expectations during the remainder of the notice period and following termination. Confidentiality and non-disparagement also fall in those categories. You can certainly put together a notice that gets sent to the employee or talk with counsel, and counsel can help you put this together as well. What happens if something goes wrong during that notice period? The employee breaches the contract, doesn't show up, doesn't take call, or does something else like that. You do not need to honor the notice period if a breach of contract has occurred. Instead, you look to the breach provisions of the contract. Is the breach curable? Does the breach immediately terminate the agreement? That can happen sometimes during a notice period. If you're not sure what your contract says or how to respond to a breach, you can always talk to counsel. Finally, what other things do you need to look out for during the notice period? One of the most important things is that while employees may be setting up and getting ready to go work for a new employer, it's really important to understand that many of them do not always honor this obligation. So I like to remind my clients to make sure that the expectation that information such as patient records and patient lists not be copied downloaded or otherwise removed from the practice. And this is something certainly to include in that response that's provided to the employee. But there's also a little bit of oversight that I recommend employers provide in terms of making sure that they're keeping an eye on their own internal systems, their EMR, and their records to make sure that nothing is removed. It's a good idea to have an open line of communication with an employee that is leaving to remind them of the expectations in terms of how they need to conduct themselves, both through the last day of their employment and following termination. There's certainly a lot more to think about when it comes to an employee's termination. And if you have any questions, feel free to reach out. We haven't even covered here termination for cause, which I will certainly cover at a later date. Thanks for listening. This is Ericka Adler from Roetzel Andress.
This video blog is made available by Roetzel and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of this video blog does not create an attorney-client relationship between you and Roetzel or any of its attorneys. This video blog should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.